My learned brothers and sisters. This is Advocate P. Devmorari talking to you from Ahmedabad city, with our state, India, that is far. First of all, best wishes for this pious, auspicious day of Raksha Bandhan. I also celebrated in the morning by wearing new thread, by performing thread ceremony and Rakhi. Well, today I've selected a very good topic, useful to all, that is attempt to murder. Indian Penal Code Section 307, Bharatiya Nyaya Sanhita 2023, Section 109. First of all, let us understand the meaning of attempt. What does it mean? In IPC Section 511, it is for attempt, and BNS Section 62 is also for the same. Attempt to commit an offense can be said to begin when the preparation are complete and the culprit commences to do something with the intention of committing the murder and which is step towards the commission of the offense. The moment culprit commences to do an act with the necessary intention, he commences his attempt to commit the offense. The word attempt is not itself defined and must therefore be taken in its ordinary meaning. What constitutes attempt is a mixed question of law and fact, depending largely on the circumstances of a particular case. An attempt means doing everything by an accused within his power to achieve result, but final result eludes because something beyond his control intervenes. That is, something comes between suddenly or the victim is saved with timely and proper medical aid after being struck. For an offense under Section 307 IPC, characteristic features of offense of murder, namely intention, preparation, and attempt must be present. The only missing thing will be death. It is an inchoate form of offense of murder. For purpose of offense to fall under Section 307 IPC, the most material ingredients is intention or knowledge and not consequences of the actual act done for purpose of carrying out intention. Unless it can be said that the intention or knowledge of the accused was to cause such bodily injury as would come within one of the four clauses of Section 300 of IPC, he cannot be held guilty of an offense under Section 307 IPC. The ingredients of Section 307 are mainly two. One is an intention or knowledge relating to commission of murder, and the doing of an act towards it. Citation year 2008 SC 904. The nature of injury caused may give considerable assistance to court in assessing knowledge or intention required under Section 307. This section makes distinction between the act of the accused and the result, if any. Now, question arises, what are the necessary factors to be taken into consideration while convicting the accused under Section 307? I'll describe certain characteristics. Nature of the weapon used, the manner in which it is used, motive for the crime, severity of the blow, and the part of the body where the injury is inflicted, scene of offense, the time of offense was committed, and not least, but very important, background of the case, if any. The intention expressed by the accused at the time of the act, मार डालूंगा, जिंदा नहीं छोड़ूंगा. Like that, if he has expressed his intention by this way. The nature and size of the injuries, the parts of the body of the victim selected for causing injuries, and the severity of the blow or blows. The intention knowledge must be such as is necessary to constitute murder. Without this, there can be no attempt to murder. Now, what is intention here? Intention is the association of will going with the act. In order to amount an attempt, under section 307 IPC, the act must be such that, if not prevented or interrupted, it would be sufficient to cause death of the victim. Citation. Yeah, 1972 SC 1764. Please remember, IPC section 307 does not punish an attempt to culpable homicide, but punishes only an attempt to commit murder. Any act which is likely to cause death is not murder. Therefore, the circumstances should be clearly proved so that one can safely come to the conclusion that if the act had caused death, the accused would have been guilty of murder. Now, there is phrase, under such circumstances. What is the meaning? The word, this is the real defense of the accused. Circumstances are very important. The words under such circumstances have been used to distinguish attempted murder from attempted culpable homicide, not amounting to murder. I've tried my best to find out certain citations, but I failed to get many. But I'm successful to get one citation. That is, year 1943, Nagpur 145. Alternate 44, CRLJ 542. 512, sorry. The expression under such circumstances refers to facts which would introduce a defense to a charge of murder, such as, for instance, the accused was acting in self-defense. This is also a circumstance, very important circumstance. Or in the case of military duty. Yeah, 1932, Bombay 279. But the act of the accused under section 307 IPC is in defense of property or person. Conviction under section 307 IPC is unjustified. 1982, in bracket 1, Bombay CR 938. When the diseased and injured persons were found to be aggressors, this is a very important point in cross case also, the plea of private defense set up by the accused would be acceptable and he will be acquitted. 2010, in bracket 2, crimes 85, Chhattisgarh. Accused would be said to have acted in his defense as there was clear and imminent danger of life and was a member of his family, and therefore acquittal of the accused is proper. 1996, Criminal Law General 3091. Now this is a very good defense. Medical papers of complainant in primary health center. We had gone for treatment, not mentioning name of assailant, though it was medico-legal case. Conviction of accused liable to be set aside. Yeah, 1997, SC 1526. Another defense. The case papers about admission and treatment of patient are not produced on record. Then doubt is created whether the victim sustained injuries due to accident or someone else has caused him the said injury. And some accused could not be convicted under, so the accused could not be convicted under section 307 IPC and deserved to be acquitted, giving benefit of doubt citation. In bracket 1997, bracket complete, 4 crimes 442, Bombay. This is also important defense, but the genesis of the occurrence was not true. Accused would be entitled to benefit of doubt. Offense under Section 307 IPC does not involve moral turpitude. Thus, petitioner selected as constable in police charged with an offense under Section 307 IPC but acquitted cannot be denied appointment later in government service. He can get government job. Where the prosecution had failed to prove that injuries inflicted were sufficient in the ordinary course of nature to cause death, and also, besides, the intention of accused was not established. The accused could not be convicted under Section 307 IPC 1993, Maharashtra LR 529, Division Bench, Bombay. When the shots could not be effective from the other side, then question of commission of offense under Section 307 IPC does not arise. 1984, CRI LR 40, Division Bench, Rajasthan. No one can be held responsible for offense under Section 307 IPC only on presumption if there is nothing specific for a time or life of injury. No presumption will have. Now the meaning of such intention, this phrase is used, such intention. What is the meaning of that? The word such intention refers to the intention referred to in Section 300 IPC, namely intention to cause death, that is first. Second, intention of causing such bodily injury as the offender knows to be likely to cause death of the person to whom the harm is caused. Or C, intention of causing bodily injury to any person, but the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Citation 1970, Criminal Law Journal, 653, Division Bench, Rajasthan. Now the last question, whether this case can be compounded. Yes, but when? Offences which are not compoundable cannot be compounded by the court. However, under Section 482 of CRP Code, where complainant had filed affidavit to compromise petition and further stated that accused are neighbors and there is a harmonious relationship between them and they are living peacefully, proceeding against accused can be quashed. Citation AR 2014, Supreme Court 3055. Another citation AR 2015, SC Criminal 166, alternate 2014, Criminal Law General 3935. This is a deep subject. In short, in a precise manner, in a very efficient manner, I've presented this video. For all my learned brothers and sisters, this is the end of the video. Thank you very much for patient hearing. Please subscribe this video if you are not. If you already subscribed, then like it, share it. See you in the next video. Sri Krishna Saranam Mama.